the questions that we can all learn from. So Matt, thank you for coming, and take it away.
Thanks again for having me. It's always a great, I can hear myself now. Good morning, everybody. I always appreciate the invitation and opportunity to come out. It's also a lot of fun doing this on video because we get to magnify the message, but I really would encourage everybody who's here today as well. If you have questions, feel free to ask. Use the resources that you have in the chat as well, and we'll feed them over and answer them as appropriate. I think that there is a microphone here, so if you're here in person and you want to ask questions, make sure you wait for the mic so that everybody who's watching virtually can also hear the questions. But if for some reason you start talking, I'll repeat the question for those following at home. We've done this a few times. Thanks for recentering me. I was trying to figure out dyslexia is not a really good thing when you're seeing yourself in reverse. So, as mentioned, my name's Matt Troiani, Vice President of Professional Development, Chief Counsel, bottle washer, cook, whatever they need me to do for the Northern Virginia Association of Realtors. I'm very happy to be here today. I got to do the lawyer thing, of course. Those of you who have heard me speak before or have gone on the legal hotline know I'm a lawyer, but I'm not your lawyer. I represent the association. I'm happy to provide legal information and analysis. Just understand it's not advice or representation. As long as we're cool with that, I think we will get along just fine.
You get quoted all the time.
Right? Quoted,
all
misquoted. It happens all the time. It has happened in professional standards hearings as well. Somebody, asked me a question, only gave about, 50% of the facts involved, and then you get quoted in the hearing. Well, Chief Counsel said that I am right. Well, first of all, those of you who know me know that I would never say that anyway. But secondly, maybe it's a little bit more complicated than that. So don't be surprised if occasionally the first response are a lawyer's two favorite words. It depends. And I don't do that just to be a crutch or just to be glib, but because so often the analysis really depends on the facts. And so let's walk through the analysis. I think that's actually a really good teaching tool, is to not just tell you yes or no. It's, hey, let's walk this through so that you understand how to apply the analysis in a variety of contexts. So with that, though, we're here to talk about July 1 standard forms updates. And we can also get into, like Dave said, we can get into Q&A. We can get into any legislative updates. There weren't a ton this year, really. For July 1, the Virginia legislature was tied up on some other things, but some positive movement there. All right. Oh. I could just say next slide. That might work because this.
Need a battery?
Oh, there it goes. Great. I think it worked. Yep. There we go. Okay. So the first thing I would tell you to do is follow along. So the slides that I've prepared and that are up on the screen today are intended to, kind of give you talking points and a high-level summary. But if you actually want to see the forms themselves, guess what? We make those available. And they're not just available with whatever forms vendor or platform that you all use, although I'm sure that you have those updated. You guys are on SkySlope, right? So SkySlope has all of the forms. They've been updated and everything like that. But we also like to get the information out early. I know we're, today's Bastille Day, so we're 2 weeks into July, but it's not just about waiting until after they go live. We publish everything about 6 weeks in advance. So we actually published the forms updates, a summary along with educational versions of the forms on our website, and we do that every time around. So put a reminder on your calendar for, say, maybe mid-November. We'll have the July 1 or January 1 updates available then too. You can take a look and you can follow along to actually see what has changed. So we have updated 22 forms this time around. That, as far as I know, is a record. So that's the scary news, right? But let's all take a deep breath because it's fine. Most of the changes are not that huge. They're not that substantive. We did not go back and do the same thing that we did back with the residential sales contract on January 1, where we ripped it apart and put it back together again. These are more like technical improvements and updates and things like that. Now, the reason why we updated so many of them, though, is that you all have probably noticed we got rid of the initials. And the reason why we tried to update that many forms is because this is our core group of forms. These are the forms that are used about 96, 97% of the time. There are a few others out there that do come up that we have not had the opportunity to update yet. I'm thinking the well and septic or the contingencies and clauses addendum are probably the two most glaring ones. You have our commitment, we're going to update those by January 1, and the initials will be removed from those as well. So why did we do that? Because you all are used to it, right? Well, if somebody initials on a page, that means that I can prove that they read it, right? And if the initial's not there, it's not a legal contract, right? Well, no, that's actually not the case. We're trying to make it easier for you all to get ratified and to do contracts. And this just kept coming up on the legal hotline over and over again over the years. We would have somebody say, well, we have an 18-page contract with all the addenda and everything, and one buyer missed an initial on page 7. Are we ratified? Well, yes, of course you're ratified. Now, there may be some question about that one page if there's some kind of like cross, markings or, something was crossed out or changed on that page. Maybe you have some ambiguity on one of those terms, but you're still ratified. We write our forms in order to try to accommodate the 99% of transactions, not the 1% where things can go awry. And so we thought the Standard Forms Committee recommended and the Board of Directors approved that let's make it easier and not get tripped up on those things. A contract is a legal document. If you've signed it, guess what? The presumption is that you've read it. And if you didn't read it, that's on you. That's not your agent's job to hold your hand. It's not your, let's move away from such a CYA kind of perspective. And let's focus on how do we get ratified, clear contracts without any of those questions. Now, if you do the old-fashioned way of striking something through, and you should still do the crosshairs with the initials and things like that if you've made some kind of manual change to the form, but you don't have to go through and just check every box at the bottom of the page, okay? I promise you your contracts are still going to be ratified. The law still is going to presume that your clients read it even if they didn't. And I'll be honest, with electronic transactions, the way that the vast majority of transactions are done these days, were the buyers reading it anyway? No, they're just initially at the bottom of each page. It's just one more thing to do. So I don't think that we're really in a...
Really?
Oh, yes. Especially when...
Say it isn't so.
You can see that when you can see the timestamps for when somebody opened a contract and when they signed it. And if that's less than 10 minutes, I guarantee you they did not read it, okay? When you get something that's been opened and been signed in 30 seconds, no, they didn't read it, okay? Now, I would still encourage you all to go over the terms, familiarize your clients with the contracts. Absolutely keep doing that. Let's just not operate from this defensive posture that if somebody does an initial at the bottom of every page that somehow I've done something wrong. The other reason why I think that we used to have the initials is dating back to the times when most transactions were done manually. That it's a little bit easier to track when you're shuffling papers in and out and you don't have a digital copy of one document. You've got 12, 14, 18, 20 pages. That having the initials there was maybe slightly more important to demonstrate that, hey, yes, they've agreed to all of this. But in the modern era of, where 99% of contracts are done on electronic platforms, you have a paper trail. You literally have a documented history of the agreement, and you can go back and demonstrate, yes, they agreed to all of these things because it's part of the file that they signed, okay? So that was one thing that was kind of a major change, but an easy change to make. The other things that we've done is consistent with our guiding philosophy on the Standard Forms Committee. Let's try to make the contracts clearer. Let's try to make them more concise. I've been with the association, it'll be 5 years in September. When I came on board, the sales contract was 16 pages. It is now 11, as you will see. You all keep me around long enough, maybe I'll get that thing back down to that 2-page front and back legal that you... Probably not. The state and federal disclosures alone take up about 6 pages of our contract, but you do have our commitment that we'll continue to work on that, okay? We're trying to remove non-contractual language. I would rather that you work with your brokers, that you work with the association to become educated and informed on what that means, rather than having the document, the contract itself, tell you what to do. And so let's remove that language of, the parties are advised to this and this. No, a contract should spell out the parties' rights and obligations, period. This is what they do. It is a framework for a transaction. It is not there to hold everybody's hand to tell them, yes, this is what you absolutely have to do every step of the way. That's your all's job, okay? We're trying to be responsive to the market needs. We don't want to overreact and overcorrect. Our forms should be useful and functional in a variety of different types of markets, but we still want to make sure that they're responsive to the things that we're seeing on the legal hotline, the things that I hear from you all and from your brokers. And then finally, the forms should be used by non-attorneys, okay? Look, here's a dirty little secret, and not a lot of lawyers are going to tell you this. There really isn't that much of an art to what we do. Okay, we use lots of Latin and Middle French and things like that to make it seem more mysterious. But the bottom line is that we are trained to think a certain way, and I'm certainly proud and grateful for that training, but there isn't that much of a mystery to it. Let's make sure that we are giving you all clear, understandable terms that non-lawyers like yourselves and your clients, for the most part, can use on a day-to-day basis. So you don't need to be constantly going back to legal to be like, what does this heretofore mean? That's not what we're going for. A contract should be in the active voice. It should say seller or buyer or landlord or tenant or broker will or will not or may not, and then what they can or cannot do. And let's leave it at that. Okay? So we're going to start off with the sales contract. So we shaved one more page off. It's down to 11. We're very excited about this. But I think we've made some really significant improvements to the contract while continuing to make it shorter. So the first thing that we changed, you probably have noticed paragraph 3. Now, I say that paragraph 3, but I'm actually going to start talking about paragraph 4, and you're going to be like, what? But the two are tied together. I know that there's a lot of visibility around the Bureau of Insurance opinion letter that came out on February 4th regarding the so-called split settlements issue. Okay? We have put out a lot of information on that. I'm happy to answer questions on that, but the bottom line is we know for certain, and this has always been the case since at least 2008, the buyer gets to choose the settlement agent, and that choice, that right of the buyer, cannot be waived in writing. So what that means is that the buyer can change the settlement agent by delivering notice, not an addendum, notice. It does not require seller approval. Okay? So let's walk through a scenario, though, that is a very common one, unfortunately, right now. Let's say that the seller or the listing agent puts in the listing, seller prefers ABC title for whatever reason. Okay. Well, buyer maybe wants to use XYZ title. Now, I never encourage any parties to negotiate in bad faith, but I also understand that in a competitive marketplace, buyers will say, sure, we'll put ABC title in there to get our offer accepted, and then as soon as the ink is dry on the contract, then we'll deliver notice and we'll change to XYZ title. Okay, no problem. Clear statutory right. The buyer has the ability to do that. But before, we had escrow agent was a free fillable space. So when you're ratifying the contract, unless the brokerage was holding the EMD, chances are you were putting the settlement agent in there. So in paragraph 3, you had ABC title. And then in paragraph 4, you had ABC title. Well, it's very clear the buyer can change paragraph 4 by saying settlement agent is now XYZ. However, the escrow agent is a material term to the contract, and it is not clear that the buyer has the unilateral ability to change that term. So the buyer would have to go back and get the seller's permission to change paragraph 3 and change the escrow agent. Now the seller's upset because they feel like it was a bait and switch, or the listing agent's upset because they felt like that maybe they were being less than transparent. And so they don't want to agree to an addendum changing the escrow agent, so they're going to stick it to the buyer that way. Meanwhile, ABC title is like, I want out of this. We are not the settlement agent. We do not want to touch that EMD with a 10-foot pole. We are not the escrow agent. Get us out of it. So that creates a pain point in the contract. We want to try to avoid that. Well, what's the simplest way to do it? Rather than having escrow agent being a free fillable box that you can type in, how about we just have check boxes that are the most common scenarios? So checkbox 1, capital S settlement, capital A agent. It's a defined term. If you check that, if the settlement agent is changed, then the escrow agent changes automatically. You don't have to go back and get an addendum. It's tied to a definition in the contract. Makes it nice and easy. In the situation where the cooperating brokerage, which is the second most common scenario, I don't know if you all hold EMDs or not, but I know some do, some don't. But in that scenario, it doesn't matter, because even if you change the settlement agent, the escrow agent hasn't changed. It's still the cooperating brokerage. Now, we do also understand that occasionally there are other scenarios. Maybe one of the parties is represented by an attorney or whatever the case may be. So we do allow for an other, for that like 1 or 2% scenario where it's a little bit unusual, but 98, 99% of the time it's going to be the settlement agent or it's going to be the cooperating broker. Now we have a checkbox, one more pain point removed, one fewer thing for you all to fill out. So hopefully that's a positive change. Paragraph 13, this was just a really wonky one. Yes, sir. Make sure you speak into the microphone if you have it.
Just going back to the buyer choosing the settlement agent. A lot of builders right now, like we are, a lot of builders are saying, okay, you're getting 10,000 to 12,000 sellers, builder subsidy, but you got to use our lender and our title company.
That is allowed. They cannot tie the acceptance of a contract on using a preferred settlement agent, but they can certainly induce or incentivize another buyer or another party to do it. So you can say it is perfectly legal to say that, hey, look, you want these, incentives, you want $10,000, $20,000 worth of upgrades or anything like that. Use our lender, use our title. That's okay because that's an incentive. The buyer can take it or not. They could say, all right, fine, I care enough about using a specific settlement agent, because buyers really care about those things. Now, most of the time it's the agents driving it. We understand that. It's okay. But it's significant enough for a builder that they would like to have a little bit more control over that they're willing to put some money behind it. And then the buyer gets to make a choice. And that's an informed decision, but it is still their decision to make in that scenario. So incentives are okay. And does everybody know why the builders do that? They're not making $10,000, $20,000 on settlement. It's control. It's about making sure that the transaction's going to go through. Most of your builder contracts have very, very aggressive timelines, right? The builder can take it almost as long as they want in order to complete construction. But once that certificate of occupancy has been issued, what happens? You got to close really quick. So that's why the builders like having a lender or a settlement agent that they work with all the time involved, is because they know that once that's ready to go, they can get that scheduled and get that done really quickly. Back when I was at Stewart Title, way back in the day, we actually did a lot of closings for many of the large builders in the area, and it was always like that kind of scenario. Basically, like certificate of occupancy is issued, and we're scheduling the settlement within 3 days. So that's why they do it. It's not a money thing. It's a control, making sure that the transaction happens quickly thing.
Matt, can everybody hear me fine?
Mm-hmm.
So sorry to digress, but as a follow-on to that question, since we're talking about deposits and settlement company and incentives, like you said, so what Matt said is it's always been okay for a builder to say, we'll give you this if you close with this company.
Mm-hmm.
You don't have to close with this company, but if you don't close with this company, you don't get that incentive.
Mm-hmm.
In my experience over the last couple of years, most of the builders have moved more in the direction of tying that incentive to a lender that they have an affiliate with,
mm-hmm.
as opposed to a title company that they don't often have a direct ownership of. Some of the builders do have that, but some of them have other marketing services or just preferred title companies. So it's usually tied to the lender these days, in my experience.
And I think that, oh, please go ahead.
So can you speak, Matt, to a seller's right to do the same thing with a subsidy?
So a seller could certainly, if they wanted to, incentivize it. Now, you would probably want to run it by the brokerage for that language to make sure it's clear and enforceable. But a seller could say that, if the seller will give a credit, like a seller subsidy or something like that, of X dollars, if the buyer closes with some company. Now, of course, if there's an affiliated business arrangement between the listing brokerage and that settlement agent, you need to let it know.
And that's where we ran into that issue with our affiliated, our ownership of Cardinal Title and the Virginia Bureau of Insurance's position where it gets really close to the veil or whatever. They didn't seem to like that, as though we were directing that as the listing side.
Even the Bureau of Insurance opinion letter does give a carve-out for incentives. It specifically says it. They may not be happy about it, but that's what the law says.
Okay.
Now, but you cannot make the acceptance of the offer contingent on them waiving their right. That's the biggest thing. You can incentivize it, but you can't say, I'm only going to consider offers with settlement, ABC.
Yeah. So a seller-provided warranty or a seller subsidy, technically, in your opinion, is legal. It's fine.
It's legal.
If the
Just make
seller-
sure
yeah.
that it's not in the listing. Make sure that it makes it into an addendum if it's
An
coming from the
addendum to
seller.
the contract.
I'm sorry, not in the multiple listing service.
If the listing brokerage is going to pay for it, then you can put it in the MLS. Because remember, the MLS is a unilateral offer for compensation. That is a binding contract that is earned by the buyer's brokerage bringing the buyer. It's performance. That's okay. But if it's the seller that is going to be paying for it in any way, shape, or form like that, you want to make sure that it's in the contract. Because so the contract is between the buyer and the seller. Anything that is not actually in the ultimate contract, even if there was a preceding offer that was out there, if it doesn't make it into the contract, it's not merged into the contract. It's this very nuanced thing called the parole evidence rule. We talk a lot about it in law school. I'm sure it's very exciting to you all.
Can you repeat the questions? We're having a problem with the mic.
Oh, sorry. Okay.
Just repeat the questions when they come through.
Great.
Okay.
I will do it going forward.
Through the live stream.
Okay. So are we good on settlement agents, at least as good as we can these days? I certainly hope, and we're going to talk a little bit more about the split settlements issue here when we get to paragraph 22. So,
You got me to run out of my office. Huh?
oh, is that
Donnie
Donnie.
didn't like my question.
Hey,
Let's
Donnie,
get
what's going
back to
on?
the subject at hand, right?
I want to let you. I don't have a mic. But
I can also repeat it if you want
no,
to.
I
Yeah.
was listening to all of it. We'll talk later because that's not the interpretation I got. And we spent a lot of time going through that.
Yeah.
Because I would like to be able to offer that incentive out, but I'll let you get forward the rest of the changes. I heard going back.
Just trying to help out.
No, I'm like, now I gotta run.
No, I get it. And of course, I mean, you have to run things by counsel that can give you a binding legal interpretation. But that being said, we have all experienced instances where the government interprets things in a way that's not consistent with what the law actually says.
Sure.
And, at the end of the day, it comes down to a risk management issue. It's, all right, do we want to avoid it, or is this something that we're willing to go toe-to-toe with the state over in order to argue it? So I completely understand, but that's also how litigators, send
Look
their
at Donnie.
kids to Ivy League schools. So.
I'll let you move forward.
But with anything else, when it comes to things like that, brokerage policy is still going to dictate all of it. I'm never going to tell you not to ignore what the brokerage says. I'm just telling you that this is what the law says, and I will be the first to admit that will not be the first, nor will it be the last time the regulatory agency is taking some liberties with what the law says. So I got you, Donnie, I promise. I'm not trying to give you extra heartburn, okay?
And sorry for getting everybody off track with that. I like to take advantage of Matt when he's
Yeah,
here.
Mike, you got to let me know if you're going to be...
I want to talk to Matt first.
Well, and...
We used to offer free warranties, and we were told you're not allowed to do that.
affiliated business arrangement disclosure,
Yep.
and then make it clear who is offering it and how it's earned.
We were willing to do it. Listing agent, seller, whatever way we wanted. I know I'm killing Justin here.
Well, and the CFPB also was taking a very aggressive posture back in, you may remember those days back in like 2014, about affiliated business arrangements and things like that. I'm happy to talk about that. It did seem like they dialed back enforcement during the preceding administration. I would imagine that they're ramping up. But if you have like a marketing services agreement or a joint venture agreement or something like that, there are ways to do it. It's not considered a RESPA violation. So.
Thank you. We will speak further, Matthew.
But listen to what Donnie says. Is that good enough?
That's good enough. Donnie just wants to go back to our old policy, and I was told I can't. But I'll talk with you more. Thank you. I'll let you go on.
That would be great if we can go back.
If you make me run down again.
I'll try not to. Maybe Mr. Briggs can let me know when he's setting a trap that's gonna get me.
I'm like, Mike's gonna go down this road. I'm gonna be down there
Just stick around, Donnie. We're having fun, right? All right.
All right. So paragraph 13, I'm going to address very, very briefly because it's a minor tweak, but I think it's kind of a humorous one. So it is clear that default now under the contract, we thought it was clear before, but apparently not, that in-ground sprinkler systems convey. We actually had several cases on the legal hotline where the sellers were trying to dig them up and take them with them. I was like, are you kidding me? If there is anything that is a fixture or a plumbing, that is it. I mean, but no, apparently not. So, well, we added 4 more words to the form. Bathroom mirrors. So we're getting people arguing about, well, is it hung like a picture so you can remove it, or is it screwed into the wall like a fixture? Come on, really? All right, if it's Nana's antique mirror or something that, like a family heirloom or something that you got that you want to take with you, put in does not convey, okay? But otherwise, bathroom mirrors convey. All right, can we be cool with that? You know, we were having people arguing over this like $50 Home Depot mirrors on a like $850,000 sale. I'm like, really? So now we had to clarify that too. So this is why the contracts tend to get out of control, is because of these like crazy cases that somebody does something that you never anticipated, and we're like, oh, now we have to have a clause for that. Congrats. All right. Paragraph 22. That's fees, for those of you who are following along at home. So we wanted to clarify, this is specifically trying to address the split settlements issue, because this has been happening behind the scenes for years. The Bureau of Insurance opinion letter that came out in February, from our perspective, just restated the law. It didn't create anything. It didn't change anything. It was just the Bureau of Insurance saying, we see what's happening out in the marketplace, and we see that some of it is inappropriate, and we're watching. It was more like a cease and desist. Knock this stuff off. And believe it or not, it mostly wasn't even directed at our region. Most of it was directed at what's going down in Charlottesville, where they have like lawyers are saying, no, don't send my clients the funds, don't pay off the mortgage directly, settlement agent, send me the funds and I'll take care of it. And the Bureau of Insurance said, nope, that's not what the statute says. So it was specifically trying to address that. But they were also trying to address the issue of lay settlement agents, not lawyers, representing sellers in transactions. Now remember, the settlement agent is chosen by the buyer, but they don't represent either party to the transaction. You hear all the time people say, oh, they represent the contract. A settlement agent provides closing, escrow, and settlement services in accordance with Virginia law and pursuant to the contract. That's what they do. Okay? If you want representation, you want somebody to look at documents, negotiate fees, that is legal representation. That's all the Bureau of Insurance opinion letter really says. But that's been the understanding of the law for 20 years. Before that letter came out, though, most of this was happening behind the scenes. The seller would get their own representation, which they're entitled to do, should be legal representation, and then the settlement agent and the seller's attorney hash out the fees behind the scenes. Some parties kind of took advantage of the visibility around the issue when the letter came out and started dragging you all and your clients into the middle of that dispute. And that's what we wanted to address, because you all should not be in the middle of it. So one of the things that some parties were using was language in the contract that said the seller will pay the seller's portion of the settlement agent fee, the seller will pay their legal fees, same thing for the buyer, vice versa. Okay, well, here's the problem. Settlement agent, lawyer, are not parties to the contract. What business do they have being put into the contract in any way, shape, or form? So let's just remove this situation. Settlement agents and lawyers are heavily regulated by their own codes of professional conduct, by state law. They're allowed to charge fees to the extent that they're allowed to charge them for services rendered. Our contract doesn't have to say anything about that. So let's remove that one thing that some people are using to kind of beat sellers over the head to charge them additional fees. Let's restore it to the way that it should be, where the parties negotiate that behind the scenes. Because, look, at the end of the day, if a seller would like to have legal representation because they want somebody in their corner, like kind of keeping an eye on what the settlement agent is doing, that's fine. They can do that. But the settlement agent is also performing services which they cannot delegate according to Virginia law. Obtaining payoffs, wiring, recordation, things like that. So we can clarify that, yes, maybe the settlement agent can charge certain fees for that. But one of the things that we saw, there are some other solutions that were presented out there. And again, those may work. If you ask a lawyer a question, you're usually going to get several different answers anyway, okay? We can all have different perspectives. One of the solutions that we have seen adopted in some other contracts is to have the parties agree up front that the seller will pay like no more than X amount towards the settlement agent, toward the settlement agent's fees. We decided not to go that route for a few, what I hope are understandable reasons. Number one, all of this is about informed consent. A consumer should be able to make informed consent as to the fees that they are being charged by a professional. How often do the sellers and buyers know how much the settlement agent fees are prior to ratification? Are they all just scouring the websites and going in and looking at everybody? Probably not. Okay? So you can't make informed consent if you're agreeing to pay certain fees when you don't even know what the fees would have been charged anyway. The second piece of that is that we know that the seller can retain their own legal counsel, and a bill was enacted into law on July 1 that clarified and specified that, among other things, the seller's attorney can draft the deed, negotiate and review closing documents and things like that, and negotiate fees. It's in the statute. So, but when does the seller usually retain counsel if they're going to? Before ratification or after? Usually after, right? Well, if I'm an attorney in private practice and a seller comes to me and they say that they retain me, and then I get the contract and the contract says that they were going to pay $750, $500, whatever the case may be, and the statute says I can negotiate fees, you know what I'm going to do? I'm going to negotiate some fees. I'm going to prove my worth to my client. Okay? So again, addressing it at ratification probably, from my perspective, is not going to solve the issue because you're going to still continue to have these negotiations behind the scenes. So let's just take the third parties out of the contract. We say what the buyer and seller are going to pay for in order to get to closing, and we advise them that there may be third-party fees, including but not limited to legal fees and settlement agent fees, and leave it at that. This way, too, we also remove the argument that, let's say that the settlement agent is trying to charge the seller $500, and the seller doesn't want to pay it. They'll say, I'll pay $100 or $150, whatever the case may be. We remove the argument that it's seller breach of contract if the seller doesn't want to pay those fees. We don't want that to be a situation. We don't want transactions to fail over a couple $100 in closing costs. So that's the approach that we've taken. Does that make sense? I know it took a few extra minutes on that, but I think it's a really important thing to understand here.
Matt, you said that the code, if I heard you correctly, statute specifically states that seller's attorney can prepare the deed. That's a no-brainer. That's to be expected. And you said other settlement papers, settlement documents.
They can review and negotiate the settlement documents.
Right. Okay. So is it specifically in the statute that the settlement, the one singular settlement agent working on the buyer's side, is specifically responsible for obtaining payoff directly and not getting it from, seller's payoff, not getting it by way of seller's
It's not
attorney?
specifically in the statute, but it is in the Virginia Administrative Code. The Bureau of Insurance regulations that they've created does specifically say that that is a non-delegable duty.
Could you speak briefly to cases where there's a title defect and ultimately whose responsibility is it to take action? It's the seller's responsibility financially under our contract, but when you have a situation, so in your experience, do you see most settlement agents, they attempt to clear the title to a certain point, and if it's more complicated, then they may say, hey, seller, you and your counsel need to take action.
And that's typically the way that it is. Like you said, that the contract specifies it's the seller's duty, but a settlement agent wants to get the thing closed, right? They want to be able to provide clear title. So as long as it's not unduly onerous for them to do it, although I think most of the time what happens is when, and this is why we do recommend that even though it's not required by law, that the seller or the seller's attorney notify the settlement agent that they do have representation and do it as early in the transaction as possible, because what that does is that it gives the opportunity for the settlement agent and the lawyer to connect and say, okay, who's doing what? Earlier in the transaction, before the settlement agent starts doing extra work for which they could charge reasonable fees for. But if the seller's attorney is going to say, no, I got this, I'll take care of it, then all right, fine. Just, here's our deadline for when we need all of that, and we will assume that you're getting it taken care of. And therefore, you can bill your client whatever you're going to bill your client, but we won't do that work and we won't charge for it.
Care to venture an opinion on where this is headed? Well, first, have you seen a trend? You've seen a trend, increasing trend of seller sides, listing brokers, and their seller clients choosing to retain counsel through that may be very often it's counsel that's associated with or a co-owner of a title company that the listing brokerage regularly uses.
Which you can do. I mean, I still would do an affiliated business arrangement. I'm going to pause here in case Donnie comes running down the hall again.
Oh. But I mean, you've seen a continuing trend
It's been happening over the years, although I think one nice benefit of what's happened in the last 4 months is that more and more people are starting to understand that they're not going to send it to XYZ Title to do the seller side. They're going to send it to Dewey, Cheatham, and Howe Law Firm. Does that make sense? Or even if there's an affiliation. I mean, like you said, most of the larger title companies have a law firm or lawyers that can take clients and do private practice in association with that. It certainly should still be disclosed, but right. I think that we're seeing more visibility around that, and I continue to hope to see that. At the end of the day, it's actually not really your all's responsibility to understand the nuances of that, except to communicate that to your clients. Seller, if I don't know the settlement agent, or I've had a bad experience with the settlement agent. Hopefully that's all honest. You're being truthful about that. But if you would like to have somebody in your corner reviewing it and making sure that everything is going accordingly, you are entitled to representation, but that is legal representation, which means maybe it might be more expensive. But let the seller make the informed decision. Don't be the party that is steering that, okay? Give them the information, let them make the informed decision. Look, at the end of the day, most of the time, most settlement agents, what they provide is it's fungible, it's very similar. It comes down to mostly like expertise in customer service, right. Like who does a better job with that. But at the end of the day, the seller can decide, hey, you know what, I might end up spending a few $100 extra, but if that gives me peace of mind, then I'm willing to do that. Just make sure that it's the client making that informed decision, not you making it for them or steering them. Hi.
Having said that, how much more they go for the attorneys representing seller?
It depends.
Close into the mic.
Oh.
Yep.
Okay. So the question is that how much more? It really depends because, I mean, it's a marketplace. Attorneys are able to charge. They may decide that they'll do like a flat fee for, fairly standardized things. They could decide to charge on an hourly rate. And that has to be disclosed to the seller before they start doing work. You have to disclose what you're going to charge for your services. But also I've seen it very widely when the settlement companies were doing seller side closings. You would see some doing it for a few hundred. You see some doing it for over 1,000. And we let the marketplace decide that. The most important thing is that if your clients are looking at it, they have time. Communicate with the settlement agent. Communicate with the lawyers. Find out how much it's going to be. You can take a little bit of time to do that at the beginning of the transaction before they decide to go one way or another. Don't just say, oh, well, we're ratified and I need to have a lawyer, so let's just go take the first person that's going to do it, no matter what they're going to charge.
So if we get to know a little bit more about how much, what is approximately dollar amount they pay more if they hire attorney, then we can actually go elaborate about our sellers.
Have like a list of like law firms and settlement agents and have them reach out and get a quote.
Well, most of settlement agents now just the seller side and lumped up. Used to be have a categorized. Now
that's because they can't do it anymore. That's the whole point of the insurance letter is that the settlement agents can't do the seller side closings anymore. It has to be the law firm.
Jeez,
Yep.
more and more now. Oh,
All right. So the other big thing, and this is what allowed us to shave one more page off the contract, is there was this section that was formerly paragraph 28. I'm sure you all read it intently. Who knows what paragraph that was? The really long one that nobody read, right? It was the disclaimers and disclosures. It was like a whole page of things that basically talked about all the stuff that you all don't do. Why is this in the contract? First of all, you're going to scare the heck out of the buyers and sellers because now you've just spent an entire page in a contract telling them what you're not going to do for them. But also, it more properly belongs in the brokerage agreement. The relationship is between the brokers and the clients. That's the appropriate place to have that conversation, not in a sales contract between the buyer and the seller. The second part of it is that it was overkill. Okay? You know how I know it was overkill? Because we took that entire page and then added it to all the brokerage agreements in 2 sentences. You will not notice that the brokerage agreements are substantially longer. We just come out and say, look, brokerages and real estate agents provide real estate services. They are not title experts. They're not property insurance experts. They're not home inspectors. They're not, well and septic. They're not lenders. They're not, financiers. They're not tax advisors. They're not lawyers. They're not settlement agents. They're all of these things, surveyors, all of the stuff that you all don't do. How about we just say that rather than, so here's everything that you need to know about these things that I'm not allowed to tell you about. So let's try to remove that non-contractual language that I was talking about. It more properly belongs in the brokerage agreement, and we can do it much more succinctly while still achieving the same result.
Would you all say Matt has some pet peeves, or he had some pet peeves? Thank you, Matt, for shortening the contract.
Well, this is what happens when you spend enough time in these forms, too. You get really, there are certain things that are kind of low-hanging fruit that you start with, right, that are kind of easy. But then after a while, they're like, you know what, this thing has just been sticking in my craw for years. Let's do something about it. So, and then we made the same changes as applicable to the sales contract for unimproved land. We try to keep those documents as consistent. For a while there, I think that they were being updated separately. But now every time we make a change to the sales contract, we try to make the same applicable changes to the unimproved land contract. Okay? All right. Financing and appraisal. So the good news is it's shorter, a little bit. The good news is that we haven't changed anything substantively at all about how the contingencies work. We've just tried to make it clearer. We were getting so many questions from the on the hotline. Now, for a little while there, they kind of fell off because, we had several people who were like, what's a financing contingency? Haven't seen one of those in a few years. I hear they're coming back, though, a little bit. So financing and appraisal. We had the financing contingency. It said this contract is contingent upon the buyer doing something the buyer never does. Deliver a loan commitment letter unless they have a gun to their head, right? Well, why are we making it contingent on something that never happens? How about we just say, there is a financing deadline, and then this is what happens after that deadline. If it's the financing contingency with automatic expiration, then the contingency's removed. The contract remains in full force and effect. If it's with automatic extension, then after the deadline, now the seller has the option, they're not required to, but has the option, if they would like, to deliver a notice to the buyer that says you have 3 days to void or the contingency is removed. So let's be more active. Let's be more specific about what that means. Now, we still say that at any time the buyer can satisfy the contingency by delivering a loan commitment if they want to. I hear it happens on occasion. Or that it can be, the financing contingency can be exercised at any time before it has been satisfied, removed, or the contract goes to settlement by delivering a written lender rejection letter for the specified financing. That's how you use it. So we're just trying to be more specific, pointed, shorter paragraphs, clearer on how you go about doing that. Did the same thing with the appraisal contingency. The other thing that we've added, though, that I think that is important is it actually addressed my one least favorite word in the entire standard forms library, and it pertains to alternative financing. We had a language in there that said, should the buyer pursue alternative financing? Pursue? What does that mean? Does that mean that a buyer can't have a conversation with their loan officer about other products that they might be eligible for? I don't think that was our intent, but that sounds like pursuit to me. So instead, what we say, what I think we meant, which is, if the buyer would like to void the contract under this financing contingency, they can only do it through the specified financing. That using anything other than the specified financing to try to void the contract will not cut it. The buyer has to go back and get the consent of the seller on a new financing contingency if they've changed anything else from the specified financing. That's loan amount, that's down payment amount, interest rate, or loan type. It's not lender. Buyer gets to choose their lender, okay? It doesn't have to be the lender. The pre-qualification, pre-approval letter that you got that went along with the offer, that's not a part of the contract. Lender's a third party. They are not a party to the contract, so let's be very, very clear about this. The buyer can still shop around. It just has to be that they have to get a rejection letter for the specified financing. Loan type, amortization period, interest rate, and amounts. Okay? Are we clear on that? Yes, sir.
Yeah. Kind of, I don't know if it kind of pertains to this, but let's say a builder, again, gets the finance through in-house, JV lender. And of course, the client qualifies as a joint. But throughout the 6 months, one of them loses his job. And the same lender is saying, oops, we can't do the loan unless and until you bring 40% down or whatever.
Mm-hmm.
So is that like too
Well,
much?
then I would push them for, if you still have an active financing contingency, then I would push them for a rejection letter for the original application.
Okay.
You're not required to change that around unless the contract specifically says that you have to. Now, the builder is trying to figure out a way to keep this deal alive because, you're 6-7 months into a contract.
Right.
They've got sunk costs. They want to offload this thing, okay? And they want to offload it as quickly as possible. They want to close right after that,
Right.
right after that certificate of occupancy is issued, because that's inventory that is on there. That is an expense they do not want to have. So they're going to try to keep the deal alive. But at the end of the day, even though the lender may have an affiliated business arrangement with the builder, they still have all kinds of legal and regulatory responsibility to still follow the law and look out for the borrower at the end of the day.
Okay.
So the borrower is not required to change their financing unless there's something very specific in the contract that says that they must. In that scenario, I'd say, look, we still have an active financing contingency. I don't know when this person's going to get their job again. We no longer qualify. We're exercising that contingency.
So let's say, builder contracts are like 65 pages, 70 pages.
Yeah.
So can that act, they usually, initially when they say, okay, you can use your own lender, but hey, you need to be pre-qualified from ours.
Well, and pre-qualification, that is more of like the seller doing their due diligence.
Right.
In this case, it's the builder. But listing agents do it all the time too, right? Like, I don't know who this lender is that you got this loan from. I've never heard of them before. Before we sign on the dotted line, I want to have at least a better feeling that you're going to qualify for the financing. Would you consider doing a soft application with somebody that I know and trust? That's okay. That's part of the due diligence. That's like asking for proof of funds on a cash deal. You're just trying to mitigate the seller's risk by understanding a little bit better the buyer's financial position before you commit to a contract. Because the last thing that a builder or any seller wants to do is to be 3, 4, 5 weeks or months, in the case of a builder, down the road where they've been under contract and now suddenly they find out that the buyer can't close the deal. Now they got to start all over again. So it's perfectly appropriate to do your due diligence. You just can't force them to use a specific one. You can incentivize, but you can't force.
So,
Get a lot of builder questions out
yeah,
here.
I'm
I guess
sorry.
this is what happens out
But
west.
on
Huh?
financing and alternative finance is really important. The builder contracts are different. We're talking about the NVAR, standard form, and specified financing is a defined term, right?
Yes,
It's in the definitions paragraph.
it is.
I have a situation this morning where our agent is the buyer agent, and they made application within 7 days to the original lender, which is required under the contract to make applications in 7 days. They got along in the process, and it was determined that the initial lender, that their primary preferred lender, was not going to be able to do it. Listing agent said, hey, I've got a lender that I think can get this done. What do you say your buyers make loan application with my preferred lender? So in good faith, the buyer did that, right? So it's all within like a 30-day contingency. It was a financing contingency with automatic extension. second lender that the listing agent had recommended couldn't get it done. And so within the contingency period, the original lender issues a loan denial. Actually, both lenders did, right? And the listing agent and the sellers are trying to say, they're crying foul, saying that they went to an alternative lender and they lost, and also that they're claiming that they believe because the buyer failed to lock their interest rate and the rates rose, which everybody's familiar with that recently,
Yep.
that constitutes default. My comment
No, it
was, and this listing broker's been around a long time, and I said, remember that the NVAR document used to spell out these items enumerated that would be examples of buyer default, such as failure to lock your interest rate, and then you subsequently can't qualify on debt to income because your payment's higher. Well, that was taken out
Yes.
of the NVAR contract. So would you say that when a buyer, as long as the contingency is open, and they were acting in good faith, do they need to get, it's wise to get your loan denial letter from the original lender that they made application to within that first 7 days?
Absolutely. But I would also make an argument that even if they had been approved by the second lender and they still had cold feet, if they have a written rejection letter from that first lender to which they applied, as long as it's for the specified financing, they can still turn that one in, even if they were approved by another one.
All right.
As long as the contingency was still active.
Thanks.
This is something that everybody has to understand. What contingencies do is they shift the point in time at which the risk of default shifts in the contract. So, for instance, if you have agreed to a financing contingency, sellers understand this, that means that absent some kind of fraud or malfeasance, the buyer may be able to walk away at some point in the contract. Once the contingency is removed or satisfied or expires, as the case may be, then the risk of default now shifts to the buyer. If they no longer have the protection of a contingency, if they are not able to get the financing and don't show up at closing, now the risk is on them. They could forfeit their earnest money deposit, they could be liable for damages, whatever the case may be. If something happens like they lose their job, they have a major health event, they have, whatever it caused them to lose the ability to get the financing. Hi, Myra.
Hey, Matthew. Hi. Welcome to Samsung Properties.
Thank you.
Yeah, so what is the best proceed, let's say if I ratify the contract with this X mortgage company, but then the buyer want to switch to a different mortgage company, so...
The biggest thing you can do to protect a buyer, if you're on the buyer side, is make that written application still within the 7 days. The contract says that you've got to apply for the loan, the specified financing, and any lender required property insurance in those first 7 days. That is to ensure that the buyer at least is diligently pursuing the financing, because that was one of the things that used to be enumerated in the contract too, that we got rid of because it was just causing all kinds of confusion. But the bottom line is that if the buyer wants to maximize their protections, you don't have to apply to just one lender. Now, again, I know that there might be some costs associated with it. Maybe there's an application fee, there's a credit report, things like that. But if they're considering multiple, apply to multiple. This is a major investment. Okay, and I understand prices are high right now and people are very cost conscious, but at the same time, I'd rather spend a few $100 extra in closing costs and make sure it's done properly on a several $100,000 or maybe $1 million investment rather than trying to nickel and dime all of those things. It's the same way I feel about getting a survey. If you can't afford a $300 survey, you shouldn't be buying an $800,000 property.
Yeah,
But if they have not made loan application with that alternative lender within the first 7 days, then you should get an addendum. You think, or what do you?
I think that at the end of the day, it says that the contingency itself says that any lender or lenders, it has parentheses, it has an S, to which the buyer has applied for the specified financing. It does not say to which the buyer has applied for the specified financing in the time frame described in paragraph 2E. So I think that
loan denial is a loan denial. You have a financing contingency.
As long as you still have a financing contingency, you can get a loan denial letter from any lender for the specified financing up until that contingency.
Yeah, what are you going to do? Is the seller going to tell the judge, well, we think it's bogus? I hear that all the time.
Prove it.
I have sellers and listing agents say, well, I think that your buyer and their loan officer are colluding. They're just making an excuse because they want to buy a different property, not this one.
The burden of proof in any party that is claiming breach of contract is on the party claiming the breach. So in that scenario, if the seller is saying that the buyer is in default or breach of the contract for whatever reason, the burden of proof is on the seller to prove
Yeah,
that.
did they
So
do what the
good
contract
luck.
said? They delivered a loan to now. And conversely, Matt, in terms of removing the financing contingency, would you agree that it's still the case that if the buyer delivers a quote-unquote conditional commitment,
That contingency, the
It's
buyer
over.
no longer has any protection under the financing contingency.
because I had that happen the other day for our buyer where the loan officer, without checking with the buyer
Oh.
or the buyer agent,
That,
sent the letter at the request
that
of the
loan
listing
officer might be
agent's
liable
TC.
for the EMD at that point.
Yeah.
You know, be very, very clear with any loan companies that you work with, especially if you're working with a seller or a listing agent that is burning up that loan officer's phone, you clear everything with me and my client first. Because our contract says this, the buyer delivers the loan commitment letter, not the lender. Okay?
So in other words, so if we switch lenders, so we don't really need an addendum to.
No addendum is necessary. Lender is not a party to the contract.
Is that to say if the loan officer delivered the letter and not the buyer or the buyer's agent? I don't know.
The question is that it appears from the seller or listing agent's perspective that that was an authorized
Yes.
act by the buyer. And therefore, yeah, the buyer's probably going to lose on that one. But now the buyer's complaint is with the loan officer. It's like, yeah, you might want to make us whole or we're going to be filing a complaint with the regulatory authorities.
And
Because you were giving out confidential information without permission.
generally speaking, what constitutes if it says conditional commitment letter, obviously that
All
says-
commitment letters are conditional.
Well-
You're not going to find one that doesn't have a condition on it, even like 8 seconds before closing. They're still going to say, like, subject to all of these requirements that we have in order to close this loan.
So if it says conditional approval,
That's,
would you say that satisfies? It
I
doesn't
think that's
necessarily
close
have
enough.
to
Yeah.
have the.
This is not a science. This is an art. If they've said that, hey, you know, the loan is approved, even though we have 8 million conditions, guess what? That contingency is still removed, and the buyer no longer has protection. So keep a lock on your loan officers. We've heard more and more of that with like loan officers just delivering things to the seller without permission, and that's problematic. So.
I only have a question in regards to the commitment letter. We see more and more often current lenders, especially being on the listing side, we're getting notifications on the buyer's loan progress. And so if we receive an email saying the loan is conditionally approved but with no letter attached, does that mean it was delivered?
An email is still a letter.
Okay, thank you. Yeah, I've seen it more and more often. Being
Now, that's also
notified what's
very interesting
happening.
too, because typically speaking, commitments and
Yes, so does that
commitments and rejections should be. Now, our contract doesn't require this because this is industry practice, and we can't really specify that. But most of the time, a commitment or a rejection letter should be signed by the underwriter, not the loan officer. Because the loan officer, that's a little bit dicier because, of course, they're trying to keep the client happy. They're in the customer service role. So that's where we start getting the sellers a lot more suspicious about collusion or something like that, about, oh, you're just giving them an out, even though they could have otherwise qualified for the loan. But an email, that's in writing. So it could qualify as, if it were delivered, and it has a couple of those magic words, commitment, rejection, things like that, that could constitute delivery.
But I thought the loan officer was not the party of contract. Why delivery of loan officer would be constituted contract?
So the question was, because if the loan officer delivers it but they're not a party to the contract, why would that have some kind of effect on the buyer and the buyer's rights? Well, it's because of this doctrine in the law that we call apparent authority, that it gives the appearance that if the loan officer or the lender or the underwriter, whoever, delivered something to the seller, that they did so at the behest of the buyer. Think about it this way. When you deliver notices or things to the to the other side. Is it your client doing it, or is it you doing it? It's the same concept. You're doing it, but you're acting on behalf of your client. It's the same thing. But my point is that, and the question is around authority. From the seller's perspective, unless they have reason to believe otherwise, when the loan officer is sending it, they're doing it under the authority of the buyer, even if they didn't actually have that authority. So make sure. Now, again, this could be litigated. I don't see anybody taking this to court, really. And I don't know exactly which way it would go, but I think that most judges in the Commonwealth of Virginia would find that the lender had apparent authority to do that, and the buyer's going to lose the EMD in that scenario. So it's really important for you to be setting those expectations with everybody that you're working with, including the loan officers. The loan officer, the lender can give general updates on the status. Yeah, and what's that usually going to be? Yeah, we're working on it. We're close. We don't have a clear close yet. That's fine. Do not deliver anything in writing that is going to jeopardize my client's rights under this contract. Or I am going to sue you, or my client will sue you, or we're going to file a complaint with the regulatory authorities, okay?
There's some mortgage company now that they automatic put you like in the system to see, like as she says, so to update it what's going on with the loan. So is that technically...
General information about a loan update is fine, but
they send you everything, like what is going on, and some companies.
I would have a conversation with them about what is being shared with the other side. I think that's great from a borrower perspective to be able to access that at any time, but sharing that with somebody with whom the lender has zero legal or contractual relationship, I would be very, very, very careful about that. I used to do compliance work for financial institutions, so that's the kind of stuff that drove me nuts. Okay. I do have to kind of pick up the pace just a little bit. I appreciate everybody's questions and things, but I have a professional standards hearing I have to get to in a little bit, and I work down the road. Seller's post-settlement occupancy agreement. I'm going to just skip through this one very, very quickly. It's a bad idea. Don't do it. I know you all love this form. I don't know why, but I know that our membership loves it. This is probably tied with the escalation addendum as my least favorite form in the whole library. It's a problem. And the reason why it's a problem is because it is being used in ways for which it was never intended. As I wasn't in the room when this form was created, but as I understand it, it was created in order to provide the parties with a little bit more flexibility in scenarios where the sellers needed more time. Maybe they were doing a subsequent purchase and they needed the proceeds from the sale of their property to buy their next property. They needed a few extra days to live there, to move out, whatever the case may be, and the buyer's willing to grant that. That's fine. A post-settlement occupancy of like a week, maybe 2, relatively low risk. But what this form is being used for now is like, okay, I am in a really competitive market and I am trying to get the seller to want to consider my offer, so I'm going to give them free 2 months to live in the property. That causes problems. That's not what we intended this form to be used for. It causes problems because the longer that there is a relationship between the parties after closing, where the seller is still living in the property, but the buyer is the owner of the property, if something breaks or something happens, who's responsible? That's where we see the issues over and over and over again. I get 8-10 tickets on a legal hotline a week on this. Okay? Now you have our commitment. We are currently reviewing the post-settlement occupancy agreement comprehensively to try to rewrite it because it is a problem and I think it's being used in ways for which it's not intended. We're going to try to clarify to the buyers and sellers that this is on them to figure out post-settlement and get you all out of it as much as we possibly can. I know that they're still going to ask you, but we're going to try to make that clear up front. We're also going to try to make it clear that there is a lot of risk that is associated with this. And if this has the effect that more buyers and sellers are going to think twice before agreeing to this, I consider that a benefit, not a con. Okay? So, what did we do this time, though? Because we don't want the perfect to be the enemy of the good. We wanted to address one very specific issue with it. There's 2 paragraphs in the contract, in this agreement, that seem contradictory. Seller has a responsibility to maintain and repair the systems and make sure that the property is delivered in substantially the same condition at the end of the post-settlement occupancy as they did at settlement. But buyer bears risk of loss. The seller doesn't have an insurable interest in this property. It's not their home anymore. So they cannot get insurance on the property. They can get insurance on their personal property in effects, which it says that they're supposed to. But it doesn't say anything about what happens for the buyer. What happens if an appliance breaks? What happens if a tree falls on the house? There's a flood, there's a fire. I think that what we meant to mean by having these two different provisions is that the seller is responsible for their intentional or negligent acts or omissions. But acts of God, random things that happen, welcome to the joys of home ownership, buyer. That's on you. So we thought that's what it meant, so we came out and said it. Now it says that, first of all, it says, except as provided in paragraph 6, this is what the seller is supposed to do. And now in paragraph 6, it says, seller is only responsible for their negligent or intentional acts or omissions that cause damage to the property. Otherwise, it is buyer's risk of loss. Buyer, you better get an insurance policy on it. Oh, and by the way, your standard insurance policy probably is not going to cut it. Let your buyers know that if they are doing a post-settlement occupancy, they need to provide that form or otherwise make the insurance company aware that there is going to be an occupant in the property and for how long, because the buyer might have to get supplemental insurance coverage during that time frame. It is a different nature of insurance, and let's just say that something happened. There was a fire, there was a tree that fell, there was a flood, and then the insurance company later finds out that there was an occupant in there and the buyer wasn't living there. That would be grounds to deny coverage.
The part about seller's responsibility to deliver it in substantially the same physical condition as of settlement date or reverting back to paragraph 10.
Yes.
How specifically has that changed? Can you speak to that?
The only thing that's changed is that the seller is not responsible for anything that's beyond their reasonable control. If something happens between settlement and the end of the between the settlement and the post-settlement occupancy end, that let's just say that, we've had some wicked
Air
storms here lately.
conditioning goes out. How about?
Ooh, that's a fun one. That's a fun one. If the fact that, let's just say, for instance, that you sold a property and it was a 20-year-old HVAC unit. What level of repair or maintenance does the seller have in that scenario? The buyer bought an appliance that was reaching the end of its natural life. Even if the seller was responsible for that, what are they responsible for? They're responsible for the depreciated value of the appliance, which just died. So you know what the depreciated value of the appliance was? Maybe $5? I don't know. Certainly not several thousand. Seller doesn't owe them a new one, okay? If the seller can reasonably have it fixed and get it functioning, then I think that would be a good thing. But if push came to shove, and the seller didn't do anything that caused that system to fail, it just failed naturally, buyer, again, welcome to the joys of home ownership. You got to get yourself a new one. Let's think about it. Let's just remove the post-settlement occupancy from this thing altogether. And let's just say that the buyer bought a property and one of the appliances died a week later. Is there any question that would be the buyer's responsibility?
No, not really.
And so I would make the same analogy. It is the buyer's property. They are allowing the seller to stay in there, but that doesn't mean that the seller has to fix them or give them anything new. It just means that the seller has to, almost like again, we are very, very clear that it is not a lease, it is not a tenancy, but if you had a landlord-tenant relationship and you had a appliance that was in the property and it died, who's the responsibility to fix it? It's the landlord's, exactly. It's not the tenant's unless the tenant did something to break it. So, using these analogies, I think that it's clear that unless the seller was somehow at fault and that caused the damage, the only other thing I would say is try to get a really comprehensive home warranty if you've got a post-settlement occupancy.
So listing agents, remember that. I mean, it's not your job to advise, which is, I think, giving legal advice to the seller, to hold the buyer's security deposit hostage over these kinds of things. And this new language is not going to eliminate disputes over rent-back
particularly
securities.
as long as there's a security deposit in play, it doesn't matter what we put in the form. People are going to fight about it. I mean, that's just the reality of it.
Right.
I just think that we can come up with other ways to be more creative to solve the same problem without having how to drag out the relationship between the parties like this. I would encourage anybody, and if you have one takeaway from all of this with everything I've said for the last 5 minutes, it's that let's just not use this as a crutch. Let's think through whether or not this is appropriate for the transaction or the relationship between the parties.
An alternative might be a short-term lease.
Short-term lease does make it a little bit clearer. I mean, ultimately, at the end of the day, if the seller's not going to leave, the process for getting the seller out of the property is very similar between a lease and a post-settlement occupancy. The only difference is what we call it in court. It's a writ of ejectment versus a writ of eviction. It's basically the same procedure, though. The only other thing that I would just suggest is solve it with money. When in doubt, solve it with money. If you want, if the seller, if the buyer's trying to incentivize, if the buyer is able to lock their interest rate in a little bit longer or something like that, just postpone the settlement date. If the seller really needs the funds in order to go and do another transaction, then pay them more money, and then they can go and get alternative housing. In between. They can go stay in a hotel for a few days. They can delay the movers, whatever. Let's use other incentives that are available that doesn't create this weird kind of quasi-tenancy kind of relationship that just keeps coming up as an issue. I would just say, look, we move around the settlement date, or we figure out, all right, seller, we'll just make it worth your while. Rather than giving you 60 days free occupancy, I'll pay you extra money in the sales price, and you can go and take that money and go and stay somewhere nice until your other property is ready.
But you got to be out by settlement.
Exactly.
Yeah.
That's
I
what
mean,
would
with the
say.
changing market, you're going to see less of it.
I certainly hope so.
But it's long been a sort of a taken for granted sort of convenience item to help the transaction. And yeah, it's...
And I would just like to, something that you said earlier, Mike, I think it's really important to stress too. How can we take you all out of it? Okay? And I'm not just saying because I think that your brokerage agreement has been fulfilled on the settlement date. Reasonable minds can disagree about some of that because the post-settlement occupancy was signed while you had the brokerage agreement. My point, though, is that after settlement, and up until the end of the post-settlement occupancy, or even after that when the parties are fighting over the money, they're not asking for realtor advice. They're asking for legal advice. They're asking you to make a determination as to who is in default and what are the damages. That is not your job. That's not your job during the regular transaction. That's not your job post-settlement either. Okay? The only role that you could theoretically play is basically being a glorified go-between, a messenger. That is it. But your clients are looking for more than that. They're looking for you to solve the problem, and that is legal advice. That is beyond the scope of your license and the scope of your competency. So can we all agree that we stop doing that?
Same applies to leases, really. It's the same thing, right? When you've been a listing agent and, at the end of the lease, even if you're going to list it again for another tenant, it's not your job to referee or, provide unauthorized practice of law.
Or if you want to be a property manager, go get a property management agreement.
Dispute.
Absolutely. So.
The last question about this.
Okay.
So what about when the buyer says that they're going to occupy the property as a primary and they do the rent back? So
So the question is that what about when the buyer says that they're going to occupy it as their primary residence for the purposes of getting the financing and there's a post-settlement occupancy? That's typically why you see post-settlement occupancies that don't go beyond 60 days. Because the affidavit that the buyer is signing at closing will typically say that they are going to take occupancy within 60 days. So that's why it's still okay. It's not misrepresentation or anything like that. It used to be 90 days, but they've actually tightened it up a bit. I've seen that document way too many times. All right, lease. I don't know how many of y'all do leases, but I'll fly through this quickly. The good news is that, theoretically speaking, I guess COVID's over. Yeah, it's here. It's here to stay. But the emergency protocols that were put into place have been retired effective June 30th. So what does that mean? Well, the lease goes back to 5-day notice in the event of failure of non-payment. It has been 14 for the last couple of years, 14 days. And that notice had to include all kinds of information. You have to apply for the rental relief program, and if the tenant doesn't, then the landlord has to do it for them, and they can't take an action for eviction until they've been declined, or they refuse to participate, or they worked out a payment plan. All of that stuff is gone, okay? So the lease basically is kind of restored to normal. But we created these two other forms during the pandemic that I actually think were really helpful. The landlord notice regarding non-payment of rent and the payment plan addendum. Even though these are optional, they're still useful. But what we did was we just took out all of that COVID emergency language, and so now it's just a landlord notice. It's, hey, 5 days, you need to pay this, otherwise we'll reserve the right to pursue eviction. Pretty straightforward. We got them down to one page. Payment plan addendum as well. Again, it's completely optional, but if the landlord is willing to offer a payment plan rather than going through litigation, rather than going through the eviction process, they can do that, and the parties can come to an agreement on that. We just scrubbed all of that, like, emergency COVID language, that's all.
So as members of NVAR, dues-paying members, we're authorized to have access to those forms. Of course, this is a relatively new, the 5-day pay or quit kind of notice, right? Mm-hmm. That is a form that you would say we can pass along to our client, even though we may not be involved in a brokerage agreement at this point in time.
As long as the brokerage is comfortable with that, you can do that.
You know what I mean? You don't have to have a listing
generally
agreement.
recommend, you be a property manager if you're going to use these on the regular, but or fill them out for your
How long
client.
has that form been in there?
We came out with in April 2020.
2020. Thanks.
There were 3 forms that we created kind of on the fly during the pandemic because there was just stuff that was coming up left and right, and we didn't know what was happening. So the COVID-19 addendum, which we're going to touch on in about 2 minutes, and then those 2 property management forms, because we were trying to create a way to make sure that landlords and property managers were staying compliant with the changes in the law, while also facilitating keeping people in the property as best we could when the courthouses were closed and there really wasn't any other remedy. So, yes?
I have a question about landlord and tenant. Now we have compliance, there's some language there is 21 days compliance or whatever that.
Oh, that language is, so the question is about the 21-day thing. So that actually has been in the VRLTA for years, okay? There's one of the remedies that the parties have under the VRLTA. So you can always go to court. You have the options to pursue damages for failure to pay rent and things like that. But there's also a little-known piece of the VRLTA that says that if one party is in material breach of the lease, the other party is able to deliver a notice to them that says, you have 21 days to fix this issue, or the lease terminates on 30 days. So it's called a 21 30-day notice. That is just, but that's usually not related to payment. That's more of a, look, landlord, I let you know that there was this problem and mold is out of control or something through no fault of my own as a tenant. You have to get this fixed, get this cleaned up. You haven't done it. I can't live here. So you have 21 days to fix this. Otherwise, lease terminates on 30 days. That's one of the remedies that's available. And the works of the landlords too. Tenant, you have unauthorized occupants in the property. Get them out within 21 days or you're out on 30.
Now, I have a case that something non-compliance, unauthorized behavior of property. And then in the lease says notification or correspondence should be in electronic.
Okay.
And say landlord text tenant, blank blank is not authorized, please do that.
I would put it in an email. Text, the question is does text suffice for electronic communication? Technically, but it's considered less reliable and it's less favorable. Don't text. Texting's okay to set an appointment or go to meet somebody somewhere, but if it's something that's related to a legal thing, put it in writing in a proper format. Don't, not shorthand with abbreviations and emojis. Let's not do that. And also, it sounds to me like your landlord in this scenario, if they're communicating directly with the tenant, is looking for you to do things beyond the scope of your relationship with them. That's property management.
No, I know, but it is not property management issue. Landlord and tenant issue.
Yeah, but they're asking you.
I'm asking myself.
Oh, you're the landlord?
Yes.
Okay. Yeah, don't text.
See, he's got to wrap it up. You can do a follow-up legal hotline.
Yeah.
Cure.
You know how to get a hold of me. We can walk through it a little bit more.
Because it's almost 12:30.
Rental application, substantially rewritten. Still 4 pages though, so that's good. We use some clever formatting to make it a little bit easier to fill out. You still have the ability to include all the information on employment, housing history, income, debts, liabilities, and all of that, but we actually did it in a way where it's easier to fill out and you can accommodate up to 4 applicants at once. We made the language consistent with changes in the terminology in the VRLTA and also provided you all with a little bit more flexibility to be able to determine when and how and in what manner the application fee or the application deposits are paid and applied. All still consistent with the VRLTA, but it needed to be updated. It hadn't been looked at in about 7 or 8 years. The other thing that we did, which I think is really important, and I've had conversations with many agents over the years on this. I don't fully know why. I mean, I kind of know why, but I don't know why they would have hired an agent to do this. But landlords really love to see those applications, don't they? Why did you hire an agent then? You should have just screened it yourself. But they like to see it. And I had to tell everybody over the years that it is a violation of the Fair Credit Reporting Act and the Social Security Act to turn over the rental application and the credit report to the landlord, because you do not have written authorization. All that was given by the applicant was for the verifier, the processor, to review those, not the landlord. We've actually clarified that now. I still think that you all should provide a screening function. I think that is still the best practice, but we now have it in writing that the tenant is, or the applicant is acknowledging that the contents of the credit report and the rental application can be provided to the landlord to try to protect
Thanks for that.
you all. Can be, not required, but maybe. It's in the signature block. There's all this language that says that the applicant is authorizing this information to be provided to the agent and the landlord. I still, in an abundance of caution, to protect from fair housing situations, would cross out like any personally identifiable information that might tip away.
Do not email PDF copies of your tenant, the application. That application has more information that's risky than probably the credit report itself. The credit report only has the last 4 digits of the social, typically, right?
Yep.
But the rental application, if it's the paper application, has their signature, has their full social security, has their addresses, and
I've
bank
always
accounts.
said that the best practice is to create a spreadsheet with the applications and just include the objective criteria that the landlord needs in order to make a determination. Here's the credit score range, background check passed. Here's their debt to income ratio. Have we verified employment? Blah blah blah. And just leave it at that. But we've been hearing over and over again that landlords are just, really chomping at the bit to see those. So, hey, can we protect you all and make your lives a little bit easier? Then we'll do that. I used to do a lot of work on Fair Credit Reporting Act and Fair Debt Collection Practices Act. Assistance animal notice. So it used to be the approval notice. We had 2 forms, an approval notice and a denial notice. They're both very short. We could fit them both on 1 page. So now it's a checkbox. Approval or denial, 1 form. We get rid of another form. So that's a pretty easy one. I have done classes, and I could do an entire class on the whole reasonable accommodation, assistance animal issue. Unfortunately, we don't have time for that today, but we have videos online as well. Thinking about it. Okay, listing agreements and the buyer and tenant agreements. Basically, the only thing that we really changed, aside from removing the initials, is taking all of those, like 1 page of other disclaimers and disclosures from the sales contract, putting it down to 2 sentences, and throwing it into the brokerage agreements. So, and then we also removed the no check boxes from the exclusive right to lease listing agreement, kind of like we did with the right to sell in the personal property and fixtures section. We had gotten rid of all the no check boxes, so you just check yes if it applies, otherwise you leave it blank. We just did that to make it consistent. Same thing with the buyer and tenant agreements. New forms, optional lease listing information sheet. Hopefully you all are using the optional listing information sheet. For those who are aware of it, we've gotten really good feedback on that form. It provides all of the information. You can have the seller fill it out with them, upload it into the MLS. Now, prospective buyers and their agents know the information they need to write a clean offer the first time. Well, we've done the same thing for applicants now, too. So there's a lease listing information sheet that you can use, too. And it's consistent with what we did to change the rental application as well. We also created a rental application denial notice. Now, I have been very, very firm on this for many years, that I do not think that 99% of the time the landlord or the leasing agent has to give a reason for why an application was denied. There's only one scenario under the law in which you have to give something in writing for a reason why it was rejected. And that is because if you're rejecting it because of something in their credit report. Fair Credit Reporting Act requires that you deliver what's called an adverse action letter. It says that we have taken an adverse action against you, we have declined your application because of something in your credit report. This is the credit reporting agency that we pulled it from, and this is the date. You can go take it up with them. That's required by law. So we were working on something like that. And then we were hearing over and over again from members that, look, when we don't give a reason, the other side assumes it's a fair housing thing. When we don't give a reason, they assume that it's discrimination. So can you give us something that is objective, that is pre-approved, that is consistent with HUD guidelines, that if we want to, we could give a reason so that it doesn't look like it's discrimination, especially if it wasn't. You know, they didn't have sufficient debt to income. We weren't able to verify employment. We weren't able to you know, they don't make enough money. The offer of the lease was insufficient. Whatever the case may be, well, let's give pre-approved objective reasons for denying the application that is optional to use. And it also includes the adverse action. So it's a category, I think it's about maybe 8 or 9 options that you can check which apply, and one of them is the adverse action language, and you can use that to decline an application.
How about landlord simply wants to continue to accept and review additional applicants?
If that is the landlord's policy and or the leasing agent's policy that they will hold it off the market until they find something acceptable, they are free to do so. I would do so cautiously, and I would make sure that I did that consistently on every single lease that I do. Because otherwise it does look like, I'm holding out for somebody who's different than you, which that screams potential discrimination. Okay, and then removing forms. I mentioned that we have an assistance animal notice. So, well, we got rid of the denial notice because now it's all in there. And then last but not least is that at long last, the forms committee has listened to me and we've gotten rid of the COVID-19 addendum. I mean, I don't think it's really been, I think that form was created with very, very good intentions. You know, if you all remember way back to March of 2020, we didn't know what was going to happen, okay? You know, there could have been mass quarantines, there could have been, you know, shuttings of businesses and governments and banks and things that would have made performance under the contract impossible. We just didn't know. So we created a form that was intended to facilitate the parties keeping the contract alive if they could, but otherwise, if performance truly became impossible because of those effects of the pandemic that were unforeseeable at the time, that neither party was going to be in default and they could walk away because it was beyond their control. Well, we're 28, 30 months into the pandemic now. And now, according to the CDC, we're in the endemic phase, which means it's just here to stay, and we've got to manage it and live with it as best we can. But the effects of this are no longer unforeseeable. You know it's a reality. It's there. It's been around for 2.5 years, unless you've been living under a rock. It's no longer unforeseeable. So let's remove that concern, that question from the contract, because some people were also misusing it. They thought they were just getting like a buyer get out of jail free card, which is not what that meant. I can only count on maybe one hand the number of occasions where a buyer was actually able to avoid default for true impossibility because of the pandemic. Yes?
So you just mentioned 2 words, performance, you know, and basically another thing I didn't catch it. So a cash deal, overseas client says, hey, 7 days before closing, I can't do it. Why? Because I have a COVID-19 signed. And
how is that rendering it impossible for them?
That's what I said. And then, of course, Keller Williams got involved. And personal case, so I'm just saying. So it's not a get out of free jail card, right? I mean,
no.
I was looking all the readings.
It's not a contingency,
right?
First of all,
it's not, right?
And it is. This is specific legal language. Now, I know we try to avoid legalese, but we had very specific language in there that it would render performance impossible. COVID has nothing to do with the fact that they couldn't get the money into the country.
It's a cash deal. The banking system is open. Right, the banking system is open and everything. Okay.
Yeah, I mean, here's the thing too. So that's a complete other story. We could do an entire class on doing international transactions. Guess what? Unless it's coming from a few countries, you're not getting the money into the country in less than a month. Period. Yeah, there's a few countries in Europe and like Canada and Mexico that you can get money into the country within a week. Everything else takes at least a month. Okay, so make sure you build in appropriate deadlines, because otherwise you're going to be in that scenario where you're potentially in a default scenario because you can't get the money in. Because even if you get the money out of the country, okay. So I used to do international finance. This is really within my wheelhouse. Moving money and things around the globe, that's what we did. So depending on where the money is coming from, it will be transferred from a bank and it will actually be deposited into a clearinghouse in New York or San Francisco, while the Office of Foreign Assets Control actually does a trace on where that money came from to make sure that it is coming from, not coming from any entity or any country that is subject to embargoes or restrictions on capital flows. Okay? And that takes a while. And they're not allowed to release that money into the account for use until that is approved. And sometimes that can take a month, 2 months, depending on where it's coming
That's
from.
only the certain country. OFAC is only looking at those certain countries, not every country.
Well, no, but what it does is that it tries to trace it. There's a list. There's a list of like 4,000 or 5,000 persons and entities, and they actually have to go back through and make sure that at no point in the chain were they even remotely connected to it. So even if the money came like directly, let's say it came from like Dubai. The United Arab Emirates is a really common one. That's an area where, again, we have good trade relationships with them and the money can come, but a lot of the money that goes in and out of there might be coming from countries that are currently subject to an embargo. And so they have to trace it. That's called know your customer requirements that all financial institutions have to do, and they will take their due diligence, and because it is a quasi-governmental entity that's doing the review, they take their sweet time. Okay? Doesn't matter when your closing is, they could not care less. They will get to it when they get to it. Okay? I think I'm getting the hook. Thank you all for your questions, for your feedback. Feel free to, of course, you have amazing resources here through the brokerage. You can always contact us directly on the legal hotline if you have any follow-ups. Thanks, and enjoy
Thank
your
you, Matt.
summers.
I'm looking at the time, and I'm like,
Thank
holy
you.
crap,
No,
you
I
gotta-
appreciate
you
it.
gotta get going, and I'm like, it's like